Thank you, Mr. Speaker, sir, for the opportunity to talk about some of the consequential bills. I will focus in particular on Bill 16, on the State Land Budget Amendment Bill. I fully support this bill, Mr. Speaker, sir, because it does two things. First, it benefits the government and it benefits lessees in allowing a shorter time for them to process their dealings and also reduces backlogs. At the same time, it does not compromise the status of the state as a landowner. The bill proposes that the Director of Lands is no longer required for any mortgage, charge, pledge, or caveat, or for any court proceedings. But lessees are still required to apply to the Director of Lands for all other dealings, such as sales, transfers, assignments, subleases, and other developments. And these consents still remain intact. These are the consents that are under Section 13 of the State Land Act and its regulations. And these are also entrenched in the tenant's lease. Bill number 16 will not stop the Ministry of Lands from continuing with the current system they have in place of monitoring compliance of lease terms and conditions. And the proposed amendment does not hinder the process and rights of forfeiture or re-entry should the state lessees breach their lease conditions. The consent of the Director Lands can be refused by the Director Lands where there is a breach of the lease conditions or where the application is not in accordance with the law. So it is important to highlight that the removal of consent of the bill only applies to leases which are already properly issued by the Ministry of Lands and which are registered with the Registrar of Titles. So the state's authority, the state's rights over the land are preserved and are maintained under this bill. In addition to this, Mr. Speaker, sir, it's been announced in the 2020 and 2021 annual budget that the consents are no longer required for connecting water and electricity on any state leased land. This also only applies to registered leases. And this is good because it speeds up access to services that people need. It also speeds up access to businesses that might be building on state land. There's been some provisions where consent is not required on mortgages, and there's been a lot of talk about mortgages. But a mortgage over a lease does not affect the land rent, it does not affect the premium or any other term and condition of the lease. All it does, it has an impact on the economic viability of our lessees in terms of their mortgages. And it has nothing to do with land ownership. Ownership remains with the Director of Lands. Mortgage of land is only a security for the money loaned to the lessees. It is beneficial to both parties, and as a result of this amendment, the process will be streamlined, it will be faster, and it will be much easier for both parties. And if a person that is a tenant is able to get a mortgage faster, it might lead to construction, lead to jobs, lead to people getting returns, not only for the person that is leasing the land, but for people that can be employed. So it has an impact on economic growth and development in this particular country. The mortgage also does not prevent the reassessment of rent that needs to be carried out over the state land leases. The state will also benefit from that. A lessee is still bound by the terms and conditions of the lease, whether or not he or she has a mortgage and whether the mortgagee has changed. The bill also talks about charges and pledges, and both of these things, Mr. Speaker, sir, do not transfer ownership of land. For instance, the FNPF sometimes provides for the financial assistance in terms of housing loans, and they require some form of security. And in this case, a charge may be placed on the property. Or Fiji Revenues and Customs Authority might place a charge on the property if the owner fails to pay a tax, as required by the relevant act. But all of this does not reduce or diminish the authority of the lessor, but rather gives the lessee additional opportunity to maximize return on investment and at the same time pay their dues. The amendment also, Mr. Speaker, sir, talks about that consent is now not required before anyone can institute legal proceedings, because this is not practical. Thus, everyone should have the right to institute proceedings that deal with state land without having to seek consent. This creates a faster business processing that eliminates unnecessary barriers. The powers of the Director of Lands remain intact as determined by the law, as mandated by the law, and other dealings will still require consent, as I've said before. In fact, the Director of Land still has the full power to forfeit any state land if the lessee is found in breach of any terms and conditions of the lease, whether or not there's a mortgage registered on the lease. The removal of all of these bureaucratic provisions brings the Ministry of Lands into the 21st century, even though we've made a lot of progress on making these things faster, the speed at which they're processed. This will allow us to be much more efficient into the future. And the bill does not lower the value of state land. It speeds up the process by which the value of land could be raised. And it supports a quicker turnaround time for all of the dealings that we've been talking about. Other dealings that affect the ownership of the property will need the consent of the Director of Lands. And Mr. Speaker, sir, a lot of the arguments that have been made in relation to Bill 16 also apply to Bill 17. It's very important to take note of that. The arguments also apply for Bill 17. Now, statements have been made in social media by the opposition that in terms of Bill 17, that the authority of TLTB to award leases has been removed. This is not true for Bill 17. It's not true for Bill 16. There's also been statements in the social media that the lessee will decide the amount of lease to be paid. Not true for Bill 16, not true for Bill 17. Also statements in social media that there will be a reduction in the amount of money that landowners earn from the leases. Not true in Bill 16, not true in Bill 17. The Honorable Biman Prasad saying the statements that what government has been doing is creating instability. What government has been doing is not creating instability. It is these false statements on social media about the effect of the bills that is creating instability. It is those false statements that are creating misinterpretation of what this bill is all about. All these three statements are not true. And because of the way they've been put in social media, they've led to vitriol, they've made to a lot of ethnic sort of things being bandied around, and all these statements started by statements that are not factual. The Bainimarama government and the Fiji First government has a history of protecting the best interests of Itoke. We only have to look at the protections in the 2013 Constitution. For the first time ever, land acquired for public purposes is returned after it is no longer needed by government. This is not done by all of these other governments that have been talked about. Alliance government, Labour, SVT, SDL, nobody did this. Under the Fiji First and the Bainimarama government, we did not do what happened in Momi and Denara. We've never alienated land. We gave equal share of lease to all Itoke. That shows concern and care for all of the Itoke in this country. Why is Bill 16 and Bill 17 been done? It protects the rights of the landowners, and at the same time, it speeds up the process to help us into economic recovery. Honorable Biman Prasad says this is not consequential. It is consequential because right now, for us, it's not just about battling COVID, but getting our economy up to speed as quickly as possible. And both of these bills will have a part to play in that. And on that basis, Mr. Speaker, sir, I fully support the amendment bills that we have for Bill 16 and Bill 17. Mr. Speaker, sir.
I thank the Honourable Minister for his contribution.